to just talk with either other government contractors or just colleagues in the business. And so with that, I'm going to actually prepare to turn things over to our panel and host, and Shirley Collier, who is the president of Scale to Market. And the great thing about Shirley is that she has been in the seat that many of you hold, whether that's a founder, whether that's coming in to run a company that's growing, whether that's perhaps even being in an interim capacity to help someone prepare for either an acquisition, but has a number of years in this business, and she's going to facilitate our discussion with both Katie Burrows, who's a partner with Polaro Mazza, as well as Catherine Hickey, who's also a partner, and they will also share a little bit about their specific disciplines within the firm. But I'm going to turn things over to Shirley. Also, quickly, if you have any questions throughout, you can put them in the chat. We'll be monitoring those. We will take most of the questions, I believe, after the initial discussion, but just know that we're going to be monitoring the chat if you have a question that you want to add. So with that, Shirley, the screen is yours. Shirley, you're still muted.
Okay, is that better? Okay, sorry about that. So before we get started, just a brief clarification. We will not have PowerPoint presentation, but we do have a handout, but we respect your privacy. So if you do not want the chamber to share your contact information with us to send you the handout, you can opt out. So Lynn, if you would be so kind as to send that poll out to everyone. And we also ask that you mute yourself if you have not already done that. You can turn your mic back on at the very end when we do questions and answers. So because of the barriers to entry and the complexity of federal contracting, teaming has proven to be a very viable strategy for government contractors of all sizes. So today we're talking about the business and legal perspectives associated with the various forms of teaming structures and the issues that small businesses have to deal with. So to help me ferret out these issues in the GovCon world, I reached out to Polaro Mazza partners, Catherine Hickey and Katie Burrows, as you've heard earlier. But I'd like for each of them to tell you a little bit more about their background. So Catherine, can you begin?
Absolutely. Thank you so much, Shirley. And thank you everyone for making the time to attend today. We're so happy to have you here. Hopefully we can provide some helpful information for you. Before I forget, I am going to start off with a brief disclaimer, which is while we hope that the information we provide today will be helpful in guiding you in potential teaming relationships, we do want to make clear that nothing we provide today should be considered legal advice. When you are considering any particular relationship, please do consult with your own legal counsel in order to make sure that you're receiving the best guidance for your situation. So getting that out of the way, I'll give you a little brief overview of the firm and my practice. Polaro Mazza is a law firm. We've been around for several decades, based in Washington, D.C., although I am based in our Anne Arundel County office, and Katie also lives in the Anne Arundel County area. So we have a lot of clients and relationships in the Howard County Chamber business community, many businesses who work with Fort Meade, NSA, as part of Cyber Command. That is a large part of where we focus and what we do. Our firm was originally founded as a government contracting boutique, and we have since expanded over the years to provide an array of other legal services, although we have a very strong government contracting group, and we continue to provide a really deep amount of service on the government contracting side. I'll let Katie speak more to that. I am the chair of our business and transactions practice. I started my career without a focus on the government contracting industry, working with businesses of all shapes and sizes across all industries on things ranging from startup concerns, so entity formation, early stage fundraising and financings, buy-sell agreements, partnership agreements, operating agreements, dealing with letters of credit, negotiations with commercial lenders, all the way through private equity financings, venture capital financings, and then through exit scenarios. So M&A transactions, mergers and acquisitions is a large part of what I do. Since I had joined Polaro Mazza about 2.5 years ago, I do all of the same type of work for all types of businesses, but just given the nature of our client base and historical presence, I have a very strong focus in working with the corporate issues, business issues that arise for our government contracting clients and dealing with transactional issues specific to government contractors. So part of what I do is working on what we're going to focus on today, these teaming relationships, is very much a crossover of considerations on both general contracting, general business issues, but overlaid with that government contracting regulatory framework that these relationships need to comply with and operate within. And so that's why, I'm joining to give the general business side of things. And then my partner, Katie, will be providing the government contracting perspective. So that's me and my practice, Shirley. And I'm happy to turn it over to Katie to give an overview of her own practice.
Thank you, Catherine.
Hi, good afternoon. It's nice to meet everybody, and thank you again for your time today. Both Catherine and I are excited to be here. As far as my background, I focus on the litigation side of government contracts for the most part. I lead Polaro Mazza's bid protest practice within the government contracts practice group. So a large part of my practice is bid protests, whether that's at the Government Accountability Office or the Court of Federal Claims or agency level protests, both on DoD and civilian side, and whether that's defending the awardee or representing the protester who's protesting the award. I also do a lot of work in the claims arena and investigation, False Claims Act cases. I also assist and do government contracts due diligence for mergers and acquisitions deals that Catherine's working on often. So that's kind of a quick overview of my practice as far as teaming agreements and what we're going to be talking about today. That comes into play, obviously, a lot of solicitations and things that my clients are bidding on involve various types of teaming arrangements. And they also bring in affiliation issues and things of that nature that can be the subject of size protests and so forth. So that's kind of where those things intersect.
Yes, excellent. Thank you, Catherine and Katie, for that background. So our topic today is about playing well with others strategically. The challenges that some founder CEOs have is that they think that the determination and independence that is necessary to start a business may seem to conflict with the skills that are necessary to partner well with others. And like marriages, not all partnerships are successful. And that's what we're talking about today. Why do some teaming partnerships flourish while others struggle and fail? So we're going to begin with some definitions about the various teaming arrangements found in the federal marketplace. So Katie, will you kick that off?
Sure. So, in the simplest form, a teaming agreement or teaming arrangement is an agreement between two companies to perform a specific contract. Typically, this is via a joint venture or a contracting teaming agreement or via the subprime relationship. Those are the typical arrangements that we see in the government contracts context.
Mm-hmm. And Catherine?
Yeah, I mean, if we zoom out, the concept is really captured in the name, and a teaming agreement it can be a more formal, a teaming arrangement that contemplates a potential prime sub relationship in the future, or a CTA, or an even more formalized, joint venture, which is going to have a bit of a broader scope longer term. But what it really comes down to is that it's, you have to go into it with the mindset of understanding that, fundamentally we're putting together a team. So there are two factors that in my mind are very essential to the ultimate success, which is, on the team, what is the clear delineation of roles that each party is going to bring to the table, making sure that everybody has a clear understanding of what the expectations are with respect to their expertise, their services that would be provided, and, their ultimate role in the broader arrangement. And what is the goal? Clearly defined goals are very important. And I think that those two kind of basic fundamental principles of any teaming relationship that we're going to talk about today are really the core principles that are important to focus on. And, I think Katie can probably speak to this. Sometimes, not all the time, but sometimes we have clients who believe that they need to have a teaming agreement in place in order to get ahead, to keep pace with competitors, and to make sure that they're well positioned for opportunities, but they lack real specificity with respect to, with a particular teaming agreement, what is the goal going to be? Sometimes we have clients approach us and they say they want a teaming agreement they've identified the partner, but they may not have actually specifically identified the opportunity that they want to pursue. And this leads me to one of the legal principles underlying these relationships that I want to highlight, which is there needs to be a fundamental exchange of consideration when you enter into a teaming agreement in order for that to be binding under applicable law. And there are some jurisdictions where a simple teaming agreement, I'm setting aside, I'm not really talking about a joint venture or a CTA, but, what we would think of when we think of a teaming agreement, which is parties come together and say, we're going to pursue an opportunity. And if we get work, we have some idea of how we're going to perform it, whether it's through a prime sub relationship is the most common format. It's important that you not have what's considered under the law as a mere agreement to agree, which means that it lacks sufficient specificity to be a binding contract. So if you sign a piece of paper that simply says, company A is going to work with company B, and we're going to bid for work under, even if you identify the opportunity, but you don't actually lay out what the roles are going to be, or there's not some concrete requirement of what the parties are going to sign as the ultimate definitive agreement, like the subcontract, if you will, or there's not an agreement up front on, how pricing is going to work and what the duties are going to be. And even with that amount of specificity, sometimes these agreements may not be enforceable. They're looked at with a fair amount of scrutiny in a lot of jurisdictions. But keep in mind that the general principle is the more specificity you can add, the more detail, the more terms there are in there that are going to be binding upon the parties, the more likely you are to have a binding teaming agreement. So that's just something to keep in mind up front. Also acknowledging the fact that depending on where you sit in that role, you may not want it to be binding. There could be situations where you prefer to maintain your flexibility. So that's all going to depend on the circumstances, but just be aware. I think that people generally know that teaming agreements have this issue. And so keep that in mind. And if you want it to be binding, the more actual binding covenants that you have in the teaming agreement itself, as opposed to kicking the can down the road for the future agreement, the better likelihood you have that you'll be able to enforce it if you need to.
So by far the most common type of agreement that a small business is going to sign is a subcontracting agreement. So I'd like to ask you about the limitations on subcontracting.
Sure. So, as you would expect, limitations on subcontracting place limitations on the percentage of work that a prime contractor can subcontract to a company that is what they call not similarly situated. So say a company, if you had a contract that, is set aside for women-owned small business, and, similar situated would be another, women-owned small business. So there are limitations that the SBA has put in place regarding, how much you can subcontract, and, depending on who you're subcontracting to, what those limitations are. Those are found, just for your, FYI. The small business regulation is found at 13 CFR 125.6, and that lays out the kind of the ground rules for the limitation on subcontracting. There's also a FAR provision that's included in most relevant contracts, which is 52.219-14. But the FAR provision hasn't actually been updated in quite a while, and it's not kind of where the SBA regulation is. So there's a little bit of confusion around that, but I would say, generally speaking, the SBA regulation is going to override.
Okay, and Catherine, you want to add to that?
I think I don't have too much to add, other than just to highlight that along the lines of what Katie was saying, the limitations on subcontracting apply to any situation where the prime contract has a specific set aside designation. And so it's going to apply, if it's a small business set aside, it would apply with respect to your ability to subcontract to parties who are not themselves small businesses. And if you're a WOSB set aside contract, it would apply to your ability to subcontract to companies who are not WOSBs. Same for 8A companies, service disabled, veteran-owned small businesses. So it's always going to be tied to the specific set-aside status of the prime contract. So in any given scenario, you may be a woman-owned small business, but have contracts that are, simply small business set-asides. So your ability to subcontract to other small businesses who might not be woman-owned wouldn't necessarily be restricted on that particular award. So it's an award-specific issue.
So what is the ostensible subcontractor rule?
I'll let Katie take this one.
So I would say this is a really important part of SBA small business regulations, and it can be, it can result in a finding of affiliation for size determination purposes. The ostensible contractor rule can be found at 13 CFR 121.103H. But the rule is designed to prevent basically front companies. So, situations where the large business is the subcontractor to the small business, but in reality, the large business is performing the primary part of the contract. And this often happens where the work was previously performed by a large business, and the work was subsequently moved to, from an unrestricted procurement to a small business set aside. So that large business is no longer, capable of being awarded the contract as a prime. And so, as the incumbent, they can't bid on the solicitation. So sometimes a large business will attempt to form a team with a small business.
Yep.
That will be the prime, and the sub will act as the subcontractor.
And Katie, I've seen this work, and I've seen it can be quite beneficial to a small business that was the subcontractor and now they're prime. But what do the small businesses need to be aware of in those circumstances?
So in those circumstances, what the small business prime needs to be aware of is that they can't be unusually reliant on the large business subcontractor, because they risk the possibility of affiliation, or being treated as affiliated under the contract, which may take them out of, and likely would take them out of, in many cases, the size limitation for the contract. So, a contractor and its ostensible subcontractor could be, would be treated as joint ventures, essentially, for size determination purposes.
So can you give us some specificity on what constitutes unusual reliance?
So there's nothing specific in the rule itself, but there have been factors, a number of factors that are suggestive of unusual reliance. And, those include where, the proposed subcontractor is the incumbent or was the incumbent and is ineligible to compete for the procurement, as I had mentioned earlier. The small business prime contractor plans to hire a large majority of its workforce from the large business subcontractor or from the subcontractor. It doesn't necessarily have to be a large business. The affiliation, nevertheless, of two small businesses could cause the small business prime to exceed the size limitations.
And that small contractor, subcontractor was the prime.
Correct.
So all of their people were on the contract, and now it flips and they're hiring people for their company because they're the prime now.
Right. And that's not a requirement to, find unusual reliance, but it is a factor that is considered. So if you don't have that, it doesn't mean that you're not going to fall under, unusual reliance, but it is something to consider. Another factor is if the prime contractor's proposed management previously served as the subcontractor on the incumbent. So you're seeing an interplay between kind of the employees and the management. Another factor is where the small business prime lacks the relevant experience and has to rely on the more experienced subcontractor in order to win the contract.
Yeah.
So really a small business prime contractor should make sure that they retain control over how the subcontract is performed.
Yeah.
They don't want to rely on their subcontractors for financial assistance or, expect them to supply managerial experience that's needed, to manage the contract. And, most importantly, they don't want to allow their subcontractors to take over and perform, the most important aspects of the contract. So, and obviously they also, as a small business prime, you need to make sure that your company performs the requisite percentage of work.
Now, many socioeconomically certified companies misunderstand the rules regarding similarly situated entities. Can you explain what this means, what this terminology means to the SBA?
Sure. We touched on this before, but under the SBA regulations, a similarly situated entity is a company that, as Catherine mentioned, shares the prime contractor's socioeconomic designation, but is also a small business under the NICS code that's assigned by the prime contractor to the subcontractor. Mm-hmm. So, this also applies to contracts that have been set aside for small businesses or 8A participants. But it's important to note that NICS code assignment is from the prime to the sub. It doesn't have to be the same NICS code that's on the prime contract.
Okay, Catherine, do you want to elaborate on that?
No, I think Katie covered it, and it was very much in line with what I touched on before, which is that it is a contract specific designation. So similarly situated for the purposes of the work that the prime contractor is subcontracting. The relevant point is what is the set aside designation on the prime contract. So whether it's small, woman owned, if it's an 8A set aside, those would be the factors that would be used to determine whether or not the subcontractor is similarly situated. That's something that you need to keep in mind when you're hitting up against those limitations on subcontracting thresholds.
So I want to clarify, because I have clients that get into this situation. So let's say that your company is a woman-owned small business. There's a procurement that you've won. That's a woman-owned small business set aside. Under the rules, WOSBs have to perform 51% of that contract. but that 51% can be comprised of the prime and other WOSB subcontractors. So collectively, they can perform 51%. Is that correct?
Yes, and they have to be small under the appropriate NICS code.
Okay. Okay. That was that the prime contract was awarded under.
No, no. So it's not, the prime contractor has to be small under the NICS code on the prime contract, but the subcontractor has to be small under the NICS code that's applicable to the subcontract, which is
Okay.
the prime contractor is responsible for making that designation, because the subcontract, is going to be a portion of, the total statement of work. So there may or may not be a different NICS code that's appropriate for that subcontract. And so that may or may not make the size status smaller or larger, depending on what the NICS code is. So
Okay. Yes.
the prime contract could have a NICS code that say it's a $15 million limit for determining, size status, if you're a small business or not. And the NICS code on the subcontract, maybe it's 20 million. So there's a little bit more leeway. It also could be smaller. So that's what,
Okay.
you need to focus on that.
Yeah, so that
you
also is an area that a lot of companies misunderstand. So I want to ask you to clarify that a little bit, Katie. So let's say that there's a woman-owned small business, and let's say the size standard is 16 million, and they want to subcontract to a larger company. And they're allowed to do that, and they can assign a different NAICS code to the subcontract than what the prime contract was awarded under.
That's correct. And that larger business, in order to be similarly situated, still needs to be a woman-owned small business under the NICS code that's assigned. And it can't just be some random NICS code. It obviously needs to be appropriate for the subcontract. But
Okay.
it's not defined by the prime contract.
So if it's not a woman-owned small business set aside, let's just say it's a small business set aside, and the prime NAICS was, again, like 16 million, they could subcontract to a larger company with a different NAICS code where the size standard was maybe number of employees, and that company would still be considered small. They're
Right.
considered small under the subcontract NAICS, but they would not be considered small under the prime contract NAICS.
Correct.
Okay. Gets a little confusing.
It does. That's not cool.
Yeah.
Related to that, we got a question in the chat from Stephanie Ludlam at Edwards, just asking, when would a prime contractor assign a different NAICS code to their sub? So Katie, I think you mentioned, for any particular scope of work, a different NAICS code may apply. And, in your experience, have you seen this utilized in any specific way, or is it really just mostly designated to, the actual work that's going to be performed under that specific subcontract?
It's designated to the specific work that's going to be performed under that subcontract. So
I actually have a question that, have you ever seen this come up in your protest practice? From a size perspective, if we're dealing with a subcontract that is maybe assigned a NAICS code with a higher size standard, which enables a larger company to be performing a portion of the work, is that often or ever a focus of the challenge? That a NAICS code was perhaps improperly utilized in order to squeeze in a larger company under, the small business, so it wouldn't count against the limitation on subcontracting.
Yeah, it certainly can be if it's evident from, say the proposal or something of that nature, where you could tell. I mean, typically that wouldn't happen until probably after the fact. So it may be a contract administration issue as opposed to a protest issue. But it is possible. I mean, if it's evident from the proposal itself, and there's some information to that effect, it could be an issue for a size protest.
So I want to change the subject just slightly here and talk about the GSA CTAs because they're becoming more common. Can you explain how they work?
Sure. So the GSA, CTA is a scheduled contractor team arrangement. And it's an arrangement where 2 or more GSA scheduled contractors come together to provide a total solution to meet the government's needs. Under schedule CTAs, contractors teams can compete for orders, say that they may not qualify for independently. So there may be some things on their GSA schedule that one of them has and the other one doesn't, but together they may be able to meet all of the government's needs, so they can come together in that way to compete for those orders. The FAR provision 9.6 deals with contractor team arrangements, but that doesn't apply to GSA schedules teaming. So under those GSA schedules, contractors are allowed to use their individual GSA schedules to develop a solution for the government. That's just kind of a quick overview for GSA schedule CTAs. But it is important to note that a CTA is different than a partnership between a prime contractor and a subcontractor, because all members of the CTA are equal parties to the contract with the government, which means that each member, as I said, has to have a GSA schedule contract, and they're also going to be in privity of contract with the government. There will be a lead contractor, so a CTA lead as opposed to a CTA member, but each of those companies nevertheless will be in privity with the government. So that's different from a prime sub relationship where only the prime would have the GSA schedule and only the prime would have privity of contract with the government.
And so explain what privity means.
Sure, I can take this one. So privity it's a general contracting principle, which essentially means if you have privity of contract with another party, it means that you have the ability to directly enforce the obligations of the other party under that contract. And you have rights that you can also enforce under that contract. So in this example, in a prime sub arrangement under a traditional subcontractor teaming agreement, only the prime contractor has privity of contract with the government. That means only the prime contractor has actually signed a binding contract with the federal government. So what does that mean in this concept of privity? Well, oftentimes you'll see in a subcontract agreement between the prime and its subcontractor, there will be provisions about if the work that the subcontractor is performing under the prime contract, but through the sub relationship, involves some sort of rights or claims that could ultimately be passed through against the government, the claim equitable adjustments or things of that nature that impact the subcontract. The subcontractor doesn't have the privity relationship with the government to pursue those claims directly. So that's why you'll see in subcontract agreements, often some heavily negotiated terms around what are the obligations of the prime to act on behalf of the subcontractor in pursuing claims that may extend up through that prime relationship with the government. And similarly, the government, well, the government has its own special rights, so we won't really get into limitations on privity for them, but that's really what we mean. So the difference in a CTA is each of the members of that CTA group could interact directly with the government, has a GSA schedule contract, meaning they are under contract directly with the government. They have rights and obligations that are direct to the federal government. There's not that go between private party in the middle that would create a bit of a barrier between their ability to pursue claims directly. And then, so just one more point that I would add with respect to CTAs is we oftentimes hear clients get the terminology wrong. We get calls all the time where clients call and say, I want a CTA, here's what we're thinking about. And what they really mean is a general teaming agreement for a potential prime sub opportunity. The term CTA is actually a very narrow and very limited specific type of arrangement that is, really only applicable to these GSA schedules. So just, by way of information, when you say CTA, it means something very specific under the FAR, as opposed to a general teaming agreement, which is much more broad and can cover anything under the sun.
Yeah, thank you for that clarification. And are CTAs unique to GSA schedules?
Not necessarily. There are
Okay.
other CTAs, but they're most often, they're very prevalent in GSA solicitations. And the solicitation would expressly say whether or not a CTA is permitted or not.
Okay, excellent. So let's talk about joint ventures. That seems to be very popular right now. Can you explain the structure of joint ventures that are used in government contracting and some of the liabilities associated with them?
Sure. Under SBA's, it's important to know under SBA's regulations, a joint venture has to be a limited duration joint venture. So you can't just have, a joint venture that you can use to bid on contracts for, 10 years. The SBA regulations limit a joint venture to a 2-year term. So, and they also, Catherine can speak more to the corporate side of this, but the SBA requires that those joint ventures be unpopulated. And, an unpopulated joint venture is prohibited from employing individuals who will perform the work on the contracts. So, although a joint venture can have an employee administrative personnel, in my experience, it's rare. And most joint ventures that are under SBA, subject to SBA's rules, don't have any employees and no facilities of their own, and everything is done through the members of the joint venture typically. So Catherine, you can speak more to kind of the corporate side of things.
Sure, I'm happy to. Something to keep in mind when you're forming a joint venture, and they are incredibly common and can be a really great way to leverage complementary past performance and complementary offerings within a joint venture, which can itself bid directly for work with the government, is that a joint venture itself, while the concept of it is addressed in the FAR, and there are rules around the fact that it has to be unpopulated, which means it doesn't really have its own workforce. The joint venture partners are the ones who each deliver their own staff and employees and facilities and what have you. The joint venture itself, when you organize it, it is going to be its own entity from a corporate law perspective. And so in addition to the joint venture concepts that need to be addressed pursuant to the FAR requirements, you also need to think about from a general corporate law perspective, what type of entity am I going to form? You need to file. The most common vehicle that we see and that we typically recommend is a limited liability company, but you do need to file articles of organization to form that limited liability company. And you're also going to need to have an operating agreement under general corporate law principles, limited liability company law principles. That is the way that we draft them for our clients. Is usually it's a combined joint venture limited liability company agreement, because so many of the joint venture principles are very much overlapped with general corporate governance principles. So in terms of the decision-making board of managers, if that's going to be the way you go, you would address that in an operating agreement, but it's also going to impact, who's the lead venturer, that type of thing. So we typically combine those concepts into a single operating agreement. But I highlight this because in some situations, we see clients who form a joint venture under a simple contract that they call a joint venture agreement. And what they don't realize is that unless you specifically house that joint venture in a newly formed entity or in a specific separate entity, the default under corporate law is that it will be treated as a general partnership, but a joint venture by default, unless you've made it an LLC or made it a corporation, which you can do. I don't recommend it. But if you haven't formed a separate entity, it will be treated as a general partnership, which is not desirable from a liability perspective, from, you know, a right to, you know, profits and losses perspective, if it's going to be anything more than an even split. In a general partnership, the individual members of the partnership, so in this case, the joint venture partners, are each 100% liable for the debts and obligations of the partnership. And that means if your joint venture partner goes out and is grossly negligent in the performance of their duties to the federal government, or submits, you know, wildly inaccurate and intentionally false certifications to the government in its joint venture certifications, then those are going to be liabilities that attach to the joint venture, which each partner could theoretically be 100% on the hook for. So if your deadbeat partner then, you know, flees the country, goes bankrupt, goes belly up, you could theoretically be left holding the bag. So that's like a worst case scenario horror story, but it is important to keep in mind that you want to avoid being involved in a general partnership in these sophisticated type of business relationships if you can. So always make sure you check the boxes on the corporate organization side, as well as the joint venture FAR requirement side of things.
Yeah,
So,
sorry.
Go ahead.
I would say, you know, there are specific joint venture requirements under the SBA's regulations, so those should always be reviewed to make sure that any joint venture agreement is going to comply with those, to the extent that you're, you know, looking to receive something as a small business.
Yeah, thank you. Thank you. Now, the SB.
Sorry, there was one other point, Shirley, that I wanted to
Yep.
make with respect to the rule that generally joint ventures need to be unpopulated. I think the one exception is if you have a joint venture with security clearance, if it's going to hold cleared work and it itself has an FCL, you are, I believe, Katie, correct me if I'm wrong, permitted to employ at the joint venture level, you know, the key personnel to support that clearance. But that would be the limitation of, you know, any staff actually employed by the joint venture.
That's right. It can have its own employees to, you know, the facility security officer or something of that nature.
Thank you for that clarification. The SBA also has the all small joint venture. So what should businesses know about that program?
Sure. So I can give a bit of an overview about the All Small program. So it's tied to the Small Business Association's Mentor Protege program. And actually recently, just last year, the updated regulations merged its former 8A Mentor Protege program into the All Small program. So there's no longer an 8A specific program. This applies to all small businesses. So under this program, any small business, so you can be general small business, you can be an 8A company, you can be a service disabled veteran-owned small business, a woman-owned small business, can enter into a mentor protege agreement with an other than small or an other than specific set aside category company. Now, it doesn't have to be with an other than small. Two small businesses can enter into a mentor protege agreement if it makes sense. You know, you might have one who's much more mature but still small under their NAICS code, that you're not precluded from participating here. But the mentor protege agreement is designed to enable a more mature company to provide support, both financial, administrative, management, what have you, support to a less mature company in the interest of fostering the growth of the protege company, the smaller company. And the benefit of it is that you get certain exemptions from affiliation rules that might otherwise be tripped up by these types of, you know, very intricate support relationships between a large and a small business. So first, the companies would enter into a mentor-protege agreement, which sets forth, the types of support that are anticipated to be provided, and you submit that for approval with the SBA. And then once that mentor-protege agreement is approved, the companies involved in it can also form joint ventures. That can be a part of what is under the umbrella of that mentor-protege relationship. The benefit in an all small joint venture is, so first of all, in that joint venture, for it to qualify under the all small program, the small business participant has to own at least 51% of the joint venture and has to have the right to receive its share of profits commensurate with its ownership. So if it owns 51% of the company, it has to receive 51% of the profits. If it owns 60%, it has to get 60% of the profits. And it has to be the managing venturer. So it has to, have that lead designation in the relationship. But the benefit from a work share perspective is that under the all small mentor protege agreement in a joint venture with its mentor, the mentor can perform up to 60% of the work share in that joint venture. So you get a little bit of an extra ability for that large business to carry more of the weight without tripping up eligibility for small business set-aside opportunities.
Yeah, so the SBA has kind of sweetened the pot for larger businesses to incentivize them to enter into joint ventures of this nature that can be very beneficial to small businesses.
And one other thing that I would add, like an additional pot sweetener for those large businesses, is that once you have the mentor protege agreement in place, not only can the large business perform 60% of the work that's won in the joint venture with its protege, but if this makes sense for the mutual strategy, the large business is also permitted to take a direct equity ownership in the protege of up to 40% of the equity. So at the joint venture level, if you could, the mentor can be performing up to 60% of the work, and even on the 40% that it's not performing, it could own indirectly an additional 40% of that work to the extent it's being performed by the protege, and ultimately the economics would flow up that way. So it really can be attractive to get those large businesses incentivized to find these opportunities, partner with a small business, get a significant economic benefit out of it while, still, the goal of the program is fostering the growth of those small businesses.
That's very good. And I've also seen that if a mentor invests 40% in a protege, that frequently will lead to an eventual buyout.
Exactly. It's all because the investment, one of the requirements under the regs is it needs to be a cash infusion directly into the protege in exchange for that equity. So, you're bringing in liquidity, which is again going to be used. The goals at that point is very often to position the company for an eventual exit so that all of the participants can realize that, a return on investment.
Yeah, excellent. So the last question is about affiliation. You mentioned that terminology. Explain what you mean by affiliation.
Sure, I can. I'm going to touch on this very briefly because I could do a whole hour or more on the affiliation rules. But so I mentioned this in the context of the mentor protege program and the all small joint venture program, because those programs provide some exemptions from affiliation rules. Without those exemptions, affiliation means that with respect to a company's size standard under its applicable NAICS code, you have to take into account not only the specific company's revenues or headcount, depending on the size standard, but also the revenues and or headcount of its affiliates. And so what triggers affiliation? The most logical, or the clearest example is any majority owner. So any entity or individual who owns more than 51% of a company is automatically affiliated by ownership. But the SBA affiliation rules, what they really focus on is control. So they assume that if you own a majority of the equity of a company, you can control that company because you have the right to vote the controlling stake in the company. But control can also exist in other scenarios. And where we see this come up is oftentimes in a management scenario, if you have a board, say where there are, you have maybe a minority investor in the company. So they don't own a majority of the stock. Maybe they only own 10% of the stock. But you have a 3-person board and 2 of the 3 board members are appointed by that minority investor. That very likely is going to trigger affiliation with that investor, because the ability to control board decisions is an impermissible amount of control over the day-to-day decision-making of the company. And so that control would lead to affiliation with the investor, which may in and of itself be a problem depending on the revenues of that investor entity. But it can also, you have to continue following the whole affiliation chain. So if there were affiliation with that investor, and if that investor had other holdings, other companies that it controlled via management or equity ownership or what have you, you would need to affiliate with our first company, not only the investor, but also any of those other companies that are controlled by that investor. So it could very quickly put our first company outside of its size standard. And it would also implicate, to the extent those other companies were small businesses, their size under certain opportunities. So it can be a little bit of a tangled web, especially if you're a company that is, pursuing the potential investment from, like a venture capital company that has many portfolio holdings. These are the types of things that come into play. So it comes into play in teaming arrangements. The mentor protege umbrella of protection is a nice way that you can kind of breathe a little easier, to not have to worry too much about these affiliation rules. But outside of that context, if you're, forming joint ventures, entering into strategic relationships, the more entangled you get, the more control a large business has over your small business, the more likely that we might hit into the gray area of affiliation, and potentially, if the subject of a size protest, as Katie can attest to, could lead to potential risk of, a determination that you would be affiliated and therefore not small. And so definitely something to keep top of mind as the more intricate these relationships become. Just don't forget that affiliation is kind of always out there as a potential risk.
Catherine, I would love to do a whole session on affiliation, because as small businesses grow, they're going to run into these types of scenarios. I mean, you want to encourage them to take on investors and strategic partners and to go after larger opportunities. And invariably, these topics come up for discussion.
I should note, earlier, Catherine, you'd asked me about size protests and similar situated entities. And I think actually it would more often come up in a GAO bid protest rather than a size protest, oddly enough, because at that point you would be looking at the prime contractor and whether or not they would be able to meet the limitations on subcontracting. So, you could theoretically file a bid protest saying that the awardee, can't meet the limitations on subcontracting. There's things around that, depending on what's evident from the proposal and blah, blah, blah. But I think it would actually be more of a situation on bid protest as opposed to a size protest, because the size protest would deal with the prime, and you're not, unless there's some affiliation, which there may be with the small business, with the subcontractor, it shouldn't come into play in that aspect. So I just wanted to clarify that.
Okay, that's another topic of discussion for the Scale Up series. It's all about protest, which a lot of small businesses don't understand. I know you could. Both of you can. This is such a great conversation. But we need to end and open up for questions. But before we do, I have 10 very brief tips on some of the business factors that contribute to the success of teams. First is teams work best when the companies have complementary capabilities. So if they have the same skills, sometimes there's competition for work share. So find a partner that complements your strengths. Those complementary skills, capabilities, relationships need to be discussed and documented. Catherine emphasized this before about documenting the understanding. And teams can be small businesses that are teaming together, not just always large and small. Third, the unique value proposition of the team needs to be very clear and articulated. And the fourth tip is that there should be an agreement on the specific business development responsibilities of the partners to emphasize and to market, to get the word out in the marketplace about the capabilities of the team. So in the agreement, there should be specific business development and marketing initiatives, the procedures that should be undertaken by both parties, and all this should be spelled out in the agreement. Number 5, discuss your pricing strategy. I think that pricing and work share are the two topics that cause the most conflict in teams. So if you're an LPTA company and your partner is a value-based pricing company, you're going to run into some conflict there. So discuss your pricing strategy ahead of time. Number 6, reporting, communications, documentation, the systems that you're going to be using to manage the relationship, how many meetings you're going to have, the type of data that everyone needs to enter into the systems, all needs to be clarified up front. Before you develop a relationship, tip number 7 is to check references, just as if you would hiring an employee. Check references, past performance, and CPARS ratings. Do business with people that you trust and that you like. That's tip number 8. What I've seen the most successful teaming arrangements, especially with joint ventures, is to subcontract first on a couple of contracts, get to know one another, and then form a joint venture. Number 9, things will always go wrong, no matter what. Government contracting is very complex, business is complex, so things will go wrong. Establish conflict resolution processes up front. And the last tip is that all business relationships have an ending, and plan for that ending. So Catherine and Katie, do you have any final advice for our audience before we open up the floor for questions?
Very brief piece of advice would be, always go back and look at what the small business regulations say. They're very complex. There are a lot of regulations. So even if you think there isn't something governing an issue, there probably is.
Good advice. Good advice. Catherine, any final words?
Yes, well, Shirley, I think I'm going to echo and amplify one of the tips that you gave, which is make sure that whatever you sign with your teaming partner addresses what happens if all this goes wrong. Very often we talk to clients who, well, they're always on an accelerated timeline. The solicitation is going to come out any day and we need this agreement in place and let's just do it quick. And there's so much trust going in, oftentimes, not all the time, but oftentimes, we're raising issues about, well, what if this happens? What if this happens? And they say, that's not going to be a problem. And we all know what the deal is. So we don't need to slow it down, or we all know is what we hear a lot. But unfortunately, when things do go wrong, that's when you find out that maybe everybody's understanding of what they thought they knew is a little bit different from what the other parties to the agreement knew. So it's always best practices to get that worked out in the drafts, put it in the document very clearly, make sure everybody can read it, understand what it means. Because the last thing you want to do is to have to fight about it down the line when you don't have clear documentation. And it becomes a he said, she said, what I thought, what you thought scenario, which can become a lot more costly and time consuming. So it's always good to avoid that, plan for it in the documentation.
Excellent. So we have a couple of questions here. I think we have time for. Um, can a teaming agreement be enforced? And what is the SBA's role in enforcing a teaming agreement? Who wants to take that?
Well, so I can speak briefly to the enforceability question, and I'll let Katie speak as to what role, if any, the SBA has. That's an interesting question, which, frankly, I'm not actually sure of the answer. But from a general legal principle perspective, the answer is it depends, classic legal answer, but it really depends primarily on the jurisdiction and the governing law. So for example, in Virginia, there is some case law, there is a significant amount of case law precedent out there that calls into question the enforceability of teaming agreements. And so oftentimes when we're talking to clients who are drafting these teaming agreements, we have a conversation about what governing law is going to apply. And if you want it to be more enforceable, you may pick a different jurisdiction. But even in jurisdictions that have a history of enforcing teaming agreements, it's going to come down to the level of specificity in the document itself and the number of actual binding commitments, exchanges of true consideration in the teaming agreement itself, and not just an anticipation of the fact that, well, down the road at some point, we will enter into an agreement that has a real exchange of consideration. That's the distinction, is making sure that it's not an agreement to agree. So again, it depends, and definitely consult with your legal advisors and think about whether you would prefer for it to be enforceable or not, depending on what other opportunities there may be. And then Katie, does the SBA play a role in teaming agreement enforcement?
So that would be, if they're just like any other contractual agreement between two commercial entities, the prime sub relationship, if you want to enforce a teaming agreement, you would likely go to state court for that. And depending on which jurisdiction, like any other contract, if there may be, specificity about venue and governing law and things of that nature. And so, that would typically go to a state court. You could go to federal court, I guess, depending on what the situation is and what's involved. But typically that would be where that would be hashed out.
Yeah.
Okay, and then one final question here is, how do I keep my IP protected when engaged in a joint venture?
So I can speak a little bit to that. Whenever a business party that has intellectual property that's proprietary and that derives significant value for the business, when you're entering into a collaborative agreement with any other business party, you need to think about what are the protections going to be with respect to my IP that I might be leveraging in this relationship and that the other party may have access to. So if that's the situation, and this is not a consideration that's unique to a joint venture scenario. This could apply to any, even a general commercial arrangement where you might be entering into a joint development agreement or something, or you're going to be, providing a license to a reseller. Whenever you're disclosing your intellectual property, you want to make sure that the documentation is pretty clear about who owns what and what the rights are that are being granted to the other party with respect to accessing, using, and potentially commercializing your intellectual property. So in a joint venture relationship, you want to make sure at a very basic level that there are confidentiality provisions that clearly define what constitutes proprietary information, what constitutes intellectual property, and the fact that for both parties coming to the table, anything that they've developed prior to the arrangement, that you retain full ownership rights, that you're not actually granting any claim to ownership for the other party to have the right to your intellectual property after the fact. And to the extent they need to use your intellectual property, if you're going to be collaborating on some sort of combined solution that's going to require them to access or incorporate or utilize your IP, you want to make sure that you grant a license, but that it's limited, that it's not transferable, that that the duration of the license would end when the joint venture agreement ends. You want to make sure the terms of that license are very clear. And then with respect to any IP that's developed as a result of the joint venture, because that's often a possibility if you develop modifications to a product that maybe incorporates some of your IP, some of my IP, who owns that jointly developed intellectual property. And there are options there. You can designate one party as, look, if we're going to be using my platform and we develop something in the joint venture that's a useful modification, then I get the ownership rights. And maybe we'll negotiate that you get some sort of perpetual license, but it's going to be mine. Or maybe you're going to negotiate to have joint ownership of that jointly developed IP. There's no right answer. That comes down to the business arrangement, but it's important to think about. And if intellectual property is going to be part of what's being shared, very important to make sure that the documentation addresses. You don't want to inadvertently create some sort of license that's going to undermine the value of the IP that you're bringing to the table.
Excellent. Thank you for that very thorough answer. And I guess the bottom line is hire a good attorney to help you with understanding those options and making good business decisions. Katie and Catherine, thank you so much for sharing your wisdom with our audience today.
Our pleasure. Thanks for having us.
So Leonardo, I'll pass this back to you.
Excellent. Well, thank you again, Shirley, and thank you to our panelists. A wealth of information and knowledge that was shared, and I'm sure that for many of our participants, this is what I would call a good example of information overload.
But good information overload.
Yeah,
good information. I'm sitting there and I'm listening to Katie, round off, and that would be clause, da 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 da.
Right.
And I'm sitting here thinking, okay, well, I guess you've read that a time or two. But again, just a great discussion, and thank you all. So as we prepare to wrap up, just want to again just thank all of our chamber supporters, and as I'll again go back and ultimately share my screen just once again, just want to again acknowledge all of our panelists here, but also our GovConnects sponsors led by Tower Federal Credit Union and Kat Zabosh, BDO, Reliant Management Corporation, Aronson, followed by then Edwards, Uninet, HRNU, and BTS. And so again, thank them for their continued support throughout the course of the year. Also, as a quick reminder for those that may have joined us a little bit late, our next Biz Breakfast will be in May on the 19th with NSA, and they will have Scott Jackson from their small business office will be joining us. So that's in May. Also, just as a heads up, we have confirmed for July that the Veterans Administration will be joining us. And so, again, just a couple of things to continue to be on the lookout for. And then also just general business opportunities. On Thursday, we'll be talking about how to leverage LinkedIn in your business development activities. Also Friday, if you're looking to network, and again, as I stated earlier, to get out of the house and maybe to leave your own Keurig at home alone for the morning, come and join us for a coffee tailgate over at Silver Diner, again, over at Gateway Overlook, and that's going to be Friday the 23rd. And then lastly, May 4th, we just wrapped up a General Assembly session. And so our Regs and Eggs legislative virtual breakfast will be on May 4th. And so again, great conversation there, where we'll talk about ultimately what passed, what didn't, and why. And so again, certainly invite you to join us for that on the 4th. And so as we again prepare to wrap up, if you're here and you're not a member of the chamber, certainly want to encourage you to become a part of our organization. We have, any number of the chamber team can assist you, specifically with Morgan Simonet, our Director of Membership and External Affairs. But with that, hope you have a great rest of the day and enjoy this great weather. So at some point, get away from your screen. But thank you for spending an hour and a half with us. But get outside, enjoy this weather, and do something for yourself. And so again, thank you all and have a great day.
Goodbye, all.
Take care.
Bye.